welcome to Truth and Transparency. Happy Hump Wednesday. Welcome. Before we get started on talking about the motion in limine, we have an order in. Let's talk about this order right here. Make it nice and big for you guys. Hitler said, we have an order on a motion in limine and his family members in the courtroom. What do we got, Hitler? Well, the state requests an order pursuant to all these fancy things, allowing immediate family members of the homicide victims to be present during the entire trial, regardless of whether they are scheduled to testify. Attached to the state's motion as Exhibit S1 is a list of those individuals the state considers to be immediate families under the foregoing provisions. They are the siblings, parent, grandparents, and step-parents of the deceased. Defendant stipulates that the individuals listed in Exhibit S1 may remain in the courtroom during the trial, but asks that the court provide guidance as to the proper courtroom decorum to discourage family members from wearing clothing or apparel that could be viewed as coercive by the jury. The state agrees that the court has the discretion to issue rules regarding courtroom decorum. At the appropriate time, the court will exercise its discretion in this regard. And it's saying that nonetheless, down here, this is footer 4, nonetheless, the parties can rest assured that those attending trial will not be permitted to display in any form or media messages or signs of support or opposition related to the parties or issues in this case. Further, no demonstrations or outbursts of any kind will be permitted or tolerated. You keep your motherfucking shit in check, or I will check yourself. I will check you, says Hitler. However, in his response to the state's motion, defendant requests that his immediate family members, siblings, and parents, so 4, be allowed in the courtroom, arguing their exclusion would violate his Sixth Amendment right to a fair trial. The state objects on grounds that, while family members of the homicide victims have a constitutional and statutory right to attend trial, there is no comparable provision for a defendant's family members. The state also contends that it intends to call members of defendant's family as witnesses at trial and will ask the court to exclude any testifying witnesses from the courtroom. The United States Supreme Court has recognized that the right to a public trial afforded by the Sixth Amendment entitles a criminal defendant, at the very least, to have his friends, relatives, and counsel present, no matter with what offense he may be charged. Setting a case there. Courts recognize that having a defendant's family members present at a trial advances the values served by the right to a public trial, ensuring fair proceedings, reminding the prosecutor and judge of their grave responsibilities, discouraging perjury, and encouraging witnesses to come forward. However, like other constitutional rights, a defendant's right to a public trial is not absolute. He wants us to all know that. A partial closure of a trial, one that excludes a limited number of persons for either the entire or part of the trial, is permitted if there is an overriding interest for the closure, and the closure is, quote unquote, narrowly tailored to serve that interest. Here, the purpose for the closure requested by the state, which provides in relevant part that at a party's request, the court may order witnesses excluded so that they cannot hear the other witness testimony. I'm going to go down to this 5-footer here. The 4 exceptions to this rule do not apply. And so back up here. Again, this is a discretionary decision. While court is sensitive to the state's concerns about allowing testifying witnesses present during trial, the court is also sensitive to the fact that this is anticipated to be a lengthy trial. Oh, it is going to be lengthy. And that the defendant would like the support of his family. And then Hitler wants everybody to know that, in addition, the court understands and empathizes with the concerns that parents themselves, having done nothing wrong, would have, and the trauma they would endure because of a child being accused of and tried for a capital homicide, and their desire to be present for their child. I want everybody to understand that if his family was to be part of this sequestration, Brian Koberger, I want to know if would they be even able to talk to him during the proceeding? Moving on. Further, the scope of his family members' testimony is likely going to be limited. I've been saying that, the scope of his family members' testimony, like what are these people possibly going to be testifying to? In an effort to reach a solution that upholds the rights of both parties, the court will require the state to submit for an ex parte in-camera review. Now that means that the defense does not get to see this. It's in camera with just the judge there, Hitler. So an in-camera ex parte means not with the other party. And Hitler is basically saying, you're going to bring me what you think you are going to need from this family. So what do you think the state, I mean, you're going to tell us what they're testifying to. You're going to tell me why you need the family and what you're going to show me. So hang on real quick here. Okay. I want to change something up there. All right. So we're going to get this list of the Koberger family member. He's going to get who it intends to call at the trial for the purposes for calling each of them. The state must also identify why each family member cannot be called very early in its case in chief, and articulate why exclusion of the family member is necessary. Particularly given the unprecedented publicity of this case, which has made much of the evidence available to those who wish to know, including the proposed Koberger family witnesses. Exactly. I'll tell you the only thing that, and it's not even, what are you going to ask these people? Is this your shared Amazon account? Why did you go to Washington? Was it a planned trip for the dad? Have you ever seen the K-bar knife that was purchased through this family account? Who purchased it? Do you have personal knowledge of it? Have you ever seen it? Like things like that. Who purchased the gift card? Who used the gift card? I'm just throwing out some stuff. Anyways, so basically Hitler's like, you're going to bring all of this to me, and then the state must submit these materials no later than next week, which is April 25th, 2025. The court will provide the parties with its decision at or before the pretrial conference on May 15th, 2025. For now, the motion is granted as to the homicide victim's family. They should all be there, by the way, 100%. And it's reserving its decision as far as the defendant's family. That is how Hitler has ordered this at this point in time. That's the only order we have off of all the motion and limines that were filed. Now, Hitler's saying that he doesn't like, why is everybody filing everything under seal, right? Interesting enough, let's go ahead and do this. I want to show you guys something. Hitler says he cares about this, and why are we filing all this stuff under seal? Well, in the latest, here you go. Just to show you guys, look at all these, look at sealed, motion to file under seal. Motion to file under seal. That would be the defendant's proposed jury instructions, the defendant's trial brief, the state's trial brief, and requested jury instructions. Motion to seal defendant's responses to state's exhibit S1 to first supplemental request for discovery. Motion to seal exhibit E to defendant's fifth supplemental response to discovery. Order on motion to limine, I just read that. Order sealing defendant's proposed jury instructions. Order sealing defendant's responses to state, order sealing, order sealing, order sealing. So that's the newest and the latest with the documents as far as that's the only order that has come out from the motion limines. Now, I want to show people, in case they're not aware of this. Actually, I'll come back to it. Yeah, we'll come back to it because now let's talk about part 3, which is the breakdown again, because sometimes you don't hear it as good the first time around. So I want to show you guys now. Next up, bring on my day 1. Okay.
But not opinion. The concern that the defense has with a lot of the lab personnel is some of the loose language about the ability to testify. Well, I don't have any of that today, but I understand there's more for me to pick up, but I don't know what it relates to.
Okay.
With regard to the lab.
Adults on.
Okay, 319. We're going to talk about the make and model of the car.
This connection, and they can't do that. This is up to the jury to make the connection if this vehicle and.
Okay, so right about here.
I'm not opposed to some kind of instructions if the parties can agree on one. I would suggest the parties come to an understanding of what a term they should, as a council at least, try to use. I'm not going to try to police the experts within their own field who use that term as part of their expertise, as both experts did, state and defense in this case. But certainly would encourage council to try to avoid it as much as possible. All right, now I think we're on the make and model of the suspect.
Just so everybody hears that. Did you hear how he said?
Your Honor, this is.
He's telling people to refrain from the whole touch. Just so we're clear. Everybody knows that, right?
A motion where the words do matter. We're following up on that one. This seems appropriate. This motion, we're talking about the phrase used by the state, suspect vehicle number 1. First, this motion is grounded in Mr. Koberger's rights to due process and a fair trial. Thinking of why we have this motion, we have to remember this is a highly circumstantial case. That's what this case is about. And one of the pieces of circumstantial evidence that the state will use is a video from a house on King Road, 1112 King Road. And that video depicts a vehicle. There are several views of that video with vehicles in it. The state will also use other videos that depict vehicles or a vehicle in surrounding areas. As they said in their response briefing, they do not have one continuous video loop. So the state's piecing together several videos and calling them all suspect vehicle number 1. That invades the province of the jury to make that determination. The state has Special Agent Immel, who will testify and identify a make and model of a vehicle from one of the many clips of videos that the state will use. That make and model cannot be identified from other than one view of that. This motion is not asking the court to prohibit the state from producing the videos or producing Agent Immel insofar as his testimony matches his expert disclosure. But this is about preventing the state from saying, this is suspect vehicle number 1. This is the same vehicle in all of these video clips. That's something that the jury will have to decide after they hear evidence to make that determination. This motion is important because that has been referred to, suspect vehicle number 1 has been referred to by the state in their affidavits for search warrants and other pleadings that they've written where the state has made this connection and they can't do that. This is up to the jury to make the connection if this vehicle in 1112 King is the same one that was in 1125 Ridge Road and other various places that the state intends to show. We're asking the court for an order prohibiting the state from making the reference of this as suspect vehicle 1 to state that as a fact, not to prevent them from presenting evidence in the way of video clips or expert testimony, but just to prevent them from invading the jury box when that's up to the jury to decide if that's the same vehicle, if it's a Hyundai Elantra, and if it's consistent with one that Mr. Koberger drove at some point.
Okay.
Ashley Jennings to the podium. Ashley.
Your Honor, it is our expert opinion, who is a vehicle identification specialist, Anthony Imel. It is his opinion that the suspect vehicle, captured on various surveillance video, shares similar class characteristics to a 2014 to 2015 Hyundai Elantra.
Okay, so right here, Ashley Jennings picks her words very, very interesting. Okay, and this is what people do that are lawyers. She doesn't specify which videos that he's supposedly saying is consistent characteristics with this 5th generation Honda Elantra, okay? Why, Ashley? Why? Oh, because your fucking expert did not say that. Your expert was very specific. Very specific. He couldn't get anything out of 1112. This is fact. So Ann Taylor is saying that you're not linking all of these together by saying this is all the same car and it's the suspect vehicle as fact. Okay. That's for the jury to decide. All right. So here, Ashley then takes the podium and she says, well, our expert says this.
Typically relied on certain video. While some are better views than others, but he relied on all video from 451 Paradise, 1125 Ridge Road, 1112 King Road, and all the WSU surveillance to come up to his opinion. His opinion is based on.
Just so you know, that's not true. He looked at. Remember, I was telling you guys about this. He didn't look at all of those and say, "Okay, I compared all of these as a whole, and this is what this car is based off of all these videos." That is not what his report says.
On logical inference.
And it will come out at trial.
A review of the surveillance and footage, including observed traffic flow, the time of night, the direction of travel, and the camera timestamps. The jury should be allowed to hear his opinion, weigh that information with other testimony and other admitted evidence, and decide if they believe that that vehicle is a 2014-2015 white Hyundai Elantra. Of course, the defense will have the opportunity to cross-examine S.A. Imel. That's the process, and that's the process that should happen. There are no legal grounds to exclude this opinion or to limit it. Thank you.
Did you just hear her? Where did Ann say that she wants to limit his testimony or limit his expert opinion? Does Ashley Jennings have a serious issue with listening and comprehending what the argument is? The argument has nothing to do with Imel's expert opinion on whatever vehicle he was shown. We have an issue if you're trying to connect all of these clips as you're going to say that this is the same vehicle.
Our request is not at this stage to limit Agent Imel's opinion.
Right there, she says at this stage. Did you hear that? Now, Ann Taylor is very specific with her wording there. We're at this stage because there's another stage that everybody gets. There's going to be some voidar. We're not looking to limit that yet. We're talking about something else here, Ashley.
That's consistent with the timely disclosed report. It's our request to have an order from the court preventing the state from referring to the vehicle as one vehicle and all of these clips. Agent Imel can talk about the clips. We can view the clips with the jury, and he'll be subject to cross-examination. The motion is wholly about.
We'll say that this is the same vehicle on each of the clips. That
No.
his expertise.
No, I think he'll testify that it could be consistent. I think he'll testify he could only identify a Hyundai Elantra from the 1125 Ridge Road video, and I think that he will agree that his original opinion was that it was a 2011 to 2013 Hyundai Elantra, and I think he'll testify that only after Mr. Koberger was identified.
Not actually true, as I understand it. It was expanded before the 19th.
Let me back up. The email that I think was disclosed in the Frank's motion to the court was that he preferred a 2011 to 2013 Hyundai Elantra, but open up the search through 2016. Moscow Police Department set out their Be on the Lookout flyer for a 2011 to 13 Elantra, and that's what was sought for a long time. Agent Immel in that email did say expand that year. The change that there's a vehicle, Hyundai Elantra, that's a 2014 to 2016 came later, and that came after Mr. Koberger was identified.
Yes, and it came later because they then gave Immel on December 20th the clips from WSU. He never viewed any clips or any cameras on WSU's campus until December 20th, which is a day after ding, 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 Brian Kohlberger's name is said. And so prior to that day of December 20th, he never saw any WSU like camera footage. Okay. And he never expanded where you're going to be talking about that it's honing in on this 2014 to 2016. That comes from only viewing the WSU cameras and like, okay, that question card, whatever you guys sent me on that day, on the 20th, those cameras, that's what that is. 2014 to 2016. Hippler, it's clear. That's what's in the report.
On December 19th, and in looking at WSU footage of a different vehicle. That's putting a vehicle together much later after Mr. Koberger's been identified, not back in November of 2022 when they're trying to identify a vehicle.
I don't think that's consistent with the facts, but okay. I think the facts are.
Oh my God. He says, I don't think that that's consistent with the facts. Can you believe what? See, this is where, okay. The facts, for the record, guys, are highly disputed. When you have facts that are highly disputed, okay, the probable cause is not facts. They are facts to that side, okay? That's theirs. So Hippler saying that those are facts, okay? Well, thank God he's not the fact finder. But those aren't facts. But the facts are heavily disputed in this case. Okay. And so when he makes that comment, like, well, that's not what the facts are. That's not what the facts are. I mean, I can't believe that he's saying this. That's not what the facts are. Wait, what? Look at my face. Look at that face.
In the email, it was originally, let's look at this date range. And then he said, well, I'm more comfortable with an expanded, we need to expand the range through 2015. And that was well before Mr. Koberger was identified. Now, what BOLA went out, I don't know. I think it may have done that in two different forms at one point, but the opinion that it could be was before that time, at least as evidenced in the emails.
I agree that in that email, he said expand the search to 2016, but he was more comfortable with a certain year. So I'm trying to explain to the court where I'm coming to my request to the court.
He never viewed a video and said, okay, how Ashley Jennings started this all off by saying that he looked at all these different videos and they're all consistent with like a 2014 or 2016. Okay. That's not true. That's not true. And I personally believe that Ann Taylor is holding her shit back because I don't want anybody to know my cards, right? I don't want even these experts to know how I know that how they write a report. And if I don't call them out on certain things, then yeah, you could explain it a certain way to literally fuck with the jury. Okay. Because when the jury would read that report, if it's not broken down how I broke that whole thing down to show you guys as viewers, if you were just to look at that report, someone like Ashley Jennings would come in and fucking turn it around like a tornado.
I was asked what Agent Immel would say, and I'm repeating it to the very best of my ability. The motion is not about Agent Immel's testimony. I will be able to cross-examine him. He can talk about the videos. He can talk about moments in time where he made certain identifications and why he said.
Right there, Ann again kills it. This isn't what the motion is for. Why does Hippler want to talk to Ann Taylor every freaking motion that's up and here, this is what we're here for? They're making it into something that's not what this is for. I'm not going to sit here and argue my case right now. I'm not going to tip my hand. And that tells me that I think that Ann's a veteran and knows how they do things over there in Idaho. Okay. I'm just shocked when you actually like listen to this again and say, like, can you give me a ruling on this? Like, this man did not identify the car as the suspect vehicle. He never referred to it as the suspect vehicle. So why we're asking that the state not refer to this vehicle in all of these clips as the suspect vehicle, and that it's the same fucking car, because there is no continuous there's no continuous film. That's the question. So, and the guy that did the identifying, okay, it was question vehicle. You send me a car and I send you an email back and said, the question vehicle is that, has consistencies, is consistent with this based off of X, Y, and Z.
Said what he said in emails. I can talk to him about when the focus for 2014 to 16 changed. What I'm talking about in this motion, what I'm asking the court to exclude, is the prosecutor from standing up and telling the jury that this is the same vehicle all the way through these videos.
That would violate what I said earlier about argument before closing. They may say in opening, the testimony of the FBI specialist you will hear is that this is the vehicle that is seen on the various surveillance cams. That's different.
You need to order that. The phrasing the prosecutor has used for a long time in this case is to call the vehicle suspect vehicle 1. So that's the purpose of the motion. This is my opportunity to ask the court for an order, and that's what I'm doing. Thank you.
See right there, Ann giving it to him. We didn't give Ann enough credit. Round 1, Ann Taylor takes it to him. Shake that bell for Ann Taylor right there. This is what this motion is for. We're not talking about anything else. Period. Ashley, just.
All right. So my opinion on that really quick is I would have been referring a little bit more.
Okay. Oh, I guess court's on a break. So then we come to court not being on a break. Okay. Next up, bushy eyebrows. Hearsay versus. Okay, this is big on hearsay. Remember? Oh, well, no. When we get to the text,
We're back.
DM is considered an eyewitness, and eyewitness testimony is some of, if not the most impactful testimony in a trial. The testimony must be subject to close scrutiny before its admission is allowed. We seek that the use of the descriptor, bushy eyebrows, be excluded from use at trial because the witness with this descriptor is completely uncertain of what she remembers, and her description is derived from seeing the intruder for only a second. Whether this court applies Manson-Biggers, which I would say is not completely right on point because there wasn't a photo lineup and there wasn't a show up, or the court considers the science behind memory, the criteria you must look at is what factors influence the accuracy of the memory and make the testimony reliable, because reliability is the linchpin in determining the admissibility of identification testimony. Between Manson-Biggers and the science of memory, there are several factors that are consistently considered, and I'm going to go.
Okay, so let's be realistic here. How reliable is Dylan's, like, how reliable is anything that she said based off of the lone fact that she had all of the alcohol that she had? How anybody can say that it's reliable, you're lying to yourself. And if you want to lie to yourself, that's fine. I don't care what side of the case you're on. It's a very, would you think that that's reliable? Somebody telling whatever, man, she was drunk off her ass. I wouldn't believe anything that she was saying that night. You know what I mean? And the answer is it's not reliable. Okay. So it's just not reliable. And now it matters though with like case law, they are saying that they don't want bushy eyebrows, right? To be talked about.
Go through a few of those. Factor 1, what was the opportunity to see? This is also known as first phase of development of memory, or the acquisition phase, and distance, lighting, and duration of exposure are important. DM is uncertain about the lighting. The stairs to her left were not lit. The kitchen may or may not have been lit, and the twinkle lights in the living room may have been lit. She described seeing the person for, quote, only a second, end quote. The person may have been 3 feet from her, or he may have been walking to exit out the back sliding glass door. The back door is further than 3 feet from her door and is not visible from where she was standing.
Okay, so right there, I'm confused. You couldn't have, when you said like you only saw him, do you mean like the front of him? Okay. But right there, it's like, I can't remember. I saw him walking towards me or walking out. Like, you would be totally in a position, totally in a different place in the house if you saw him walking out of the house, because you can't see that from your door. But to be able to just use the phrase, well, I saw him walking towards the back slider, wouldn't that be the same as I saw him walking towards the kitchen or this person? Interesting to me.
We submitted 2 pictures as our exhibits to show you the vantage point of where she was standing in her bedroom. Her opportunity to see.
Those were sealed. But we've done this so many times on this channel. And we've done exactly this, where we show you the vantage point of like, okay, here, based on where DM was allegedly standing in her room with the door open, this is what your view is. Okay.
C supports unreliability. Factor 2, the witness's degree of attention. This is where amount of alcohol has a significant impact on the analysis. She described herself as, quote, probably very drunk. And given the amount of alcohol she told law enforcement about consuming the entire day, that makes sense. She started with champagne mimosas in the morning, then White Claws 9 to 10 throughout the day. Then that night before she got home, she was involved in a drinking game and drank Borg, which is hard alcohol and flavoring. Her degree of attention, given this, supports unreliability. Factor 3, the accuracy of the description. Her description is that she saw a person wearing all black, not insanely tall. She doesn't know if she saw lips and nose. She is certain he is white. She never mentions eyebrows herself initially. The person who asked about eyebrows was law enforcement. In her second interview, Detective Mowry asked her if she saw eyebrows. She never said anything about bushy eyebrows. Then in her third interview with Detective Gooch, she said she didn't know what the eyes looked like or the color of the eyebrows. That's for the first time that she mentioned bushy eyebrows. This lack of accuracy supports unreliability. Factor 4, what is the level of certainty of the witness? In each of the 5 interviews, she says over and over again, she doesn't know if anything she says is accurate because she felt like she was in a dream state, frozen shock, fuzzy and cloudy, like wearing blurry glasses, influenced by alcohol, and sleepy. She has an absolute lack of certainty.
Okay, so right there, do you hear that frozen shock? Dylan Mortensen said the words, this is part that we missed. Dylan Mortensen said the word frozen shock. That's where those words came from. What? Out of all the terms in the world, I was in a frozen shock. Where did she get that terminology? When did she use that terminology? Like, who has that? Think about the stuff that would be in your vocabulary, okay? Think about stuff that would be in your vocabulary. Dude, frozen. Dude, I was like in a frozen shock. What? And then when we find out about her texting and that she was really up at 3:51 and she just didn't wake up like how she said she did, like, wait, whoa. Think about that. Where does that come from? That's just an interesting phrase
This support
for her to have said.
Unreliability. Factor 5, the science of memory looks to confabulation. When the acquisition of memory, the first factor that I talked about, is impacted by emotion and stress. In this case, that is an important consideration. Confabulation is defined as the creation or substitution of false memories through later suggestions that fill in the gaps of missing memory. DM expresses in each interview how she was afraid and did not know what she was hearing, and also contradicts this when she thought everything was, quote, okay, and XK was simply just passed out on the floor. Later suggestion.
Okay. We have to talk about this now. Ready for this? Wait, when did she see Xana? When did she see Xana and think that she was just passed out on the floor? Did she go by her room? Right? When did she think about this? When did she see Xana? And you guys, she's not talking about that 911, like before the 911 call. Okay. So again, this is a little blurb here that we're missing. She thought that just Xana was just, she thought everything was okay and that Xana was just passed out on the floor. Wait, what? Think about that.
Under this definition of confabulation is Detective Mowry asking her about eyebrows and each law enforcement officer then reinforcing that in each interview. She never used the word balaclava, yet Detective Gooch asked her if she had ever heard of one, explained what one was and that it's used to hide identity, showed her a picture of one, and then had her draw one. This is law enforcement filling in the gaps. This also impacts the last factor, which is factor 6, post-event misinformation effect impacting retained information. Exposure to subsequent information. Law enforcement, upon initial appearance at the scene, did not ever break up all of the people that were there. They then go to the police station, and after that, on the night of November 13th, those that were at the house when law enforcement arrived stayed together in a hotel room. So the DM was basically together with other witnesses from the time that when they first called friends to come to the house, before they called law enforcement, all the way through the night. She was interviewed twice by law enforcement. That created this exposure to bushy eyebrows. And then that term was used in the probable cause affidavit, and the media seized upon it from the very beginning, causing post-event exposure, which affects how DM's memory is retained. This factor supports unreliability. When you look at all of these factors, or the totality of the circumstances, the way the state argues it, the linchpin, the reliability is not there. The state wants to bolster a person who admittedly has no clear memory with a photo of Mr. Koberger to say, this is the person she identified. DM told police that she looked at Mr. Koberger's arrest picture and did not recognize him. The state cannot run around her unreliability by entering into evidence a photo to show it's a person that she says she cannot identify, because the state's interpretation is that Mr. Koberger's photo shows bushy eyebrows. That is misleading to the jury. It will confuse the jury. It will be putting words into the mouth of DM that do not exist. While they might not seek to do that on the stand with her by admitting a photo through her testimony off of his phone, if they make the argument in an opening statement that
Okay. So this is what I think. If you go back and look at the probable cause affidavit, it is very interesting where they choose to put in the probable cause affidavit that DM didn't recognize him, because they don't show DM the photo of Brian Kober until it's after he's arrested. Okay. Right. But they wrote up the probable cause before he was arrested, right? So they had to ask her at one point, right, that she didn't recognize this person, right? And then after they arrest him and show her the picture of him, because she said, I looked up his mugshot, all right, that then she still didn't recognize him, and she thought that he would have popped out at her, even that she would expect that you could still have, if you see his eyes or his eyebrows or whatever, that, oh my God, yeah, that's fucking him. She didn't say that. And I think that that's actually very interesting, because all the swirling conspiracy theory, people talking about stuff with this case, you want to talk about somebody being told what to say, or just, yeah, when you see this, say, oh my God, that's, that's, I will never forget those eyes or something like that. That's not what happened. Dylan was actually on the opposite side of that, saying that she couldn't believe that it didn't pop out, and she has no clue if that's who it was. No clue.
that description of bushy eyebrows is supported by a photo taken on his phone the next day, that kind of prejudice is beyond repair. The state also claims that because DM draws pictures of eyes and eyebrows, she is more reliable in her identification of them.
I
But
can't
that is
believe
not
that.
the way law enforcement.
I can't believe that. You guys saw that in the motion, right? That because of her ability to write and draw eyebrows and her focus on eyebrows and bushy eyebrows, like that gives her more of credibility to know what bushy eyebrows look like. I mean, they actually wrote that. They wrote that in their motion.
Enforcement appeared to have viewed the artwork as they photographed it and reported on it. Given the science of memory and its acquisition, retention, and retrieval, this could be what is filling in her memory gaps as opposed to actual memory. When you apply the critical factors that a court must take into consideration for eyewitness testimony regarding identification, the words bushy eyebrows should be excluded. The heart of the issue is whether or not the witness is reliable enough on the issue to let the words be spoken to the jury when it comes to the description. DM said.
Okay, so do you hear what the argument is there? She shouldn't be able to say this, guys. It's not. It's like if she was to say the guy was skinny, fat, tall, black, white, it doesn't matter. She shouldn't be able to say anything. Okay? Because, well, let's just put it to you this way. I personally think that the state should say, okay. You want to know why? Because aren't you trying to protect your witnesses a little bit here? DM is going to be grilled on, well, didn't you say you saw a fireman? You know, they're going to go through all of the stuff, and why put her through that? Right? That's how I look at it. Like, is there a way to limit Dawn Mortensen in a term of like to protect her in a sense, like, because you're going to then, if you were like to stipulate to this, right? If you're on the state's, you know, if you're part of the prosecution and you're like, hey, why don't we just stipulate to this? Because once she goes ahead and says, and we elicit this type of testimony out, then they're going to have to sit there and they're going to go through all of what DM said and all of what she did that day. Okay. That's my thought on it, is that
That she could not do a composite sketch because she doesn't think she saw a face. The court should enter an order excluding the words. Thank you.
Ashley Jennings, what do you think? Jennings doing the arguing here for the state. Bushy brows.
The defendant relies on the Manson-Vickers test. We just went through the 5-factor balancing test for the argument. However, that test is completely inapplicable in this case. Manson-Vickers has to do when there's a law enforcement-led identification process. The concern is that through suggestive techniques by law enforcement, it could lead to or create a misidentification. Well, that didn't happen in this case because it couldn't happen in this case. The male DM saw that night was covered head to toe. The only thing that was uncovered was a portion of his face. That does not lend itself to positively identifying any particular person. Therefore, an identification procedure was not used, and that Manson-Vickers test is inapplicable. Instead, on 4 separate occasions, before Ryan Koberger was even identified or arrested, DM gave consistent descriptions of the male she saw in the residence that night at around 4 a.m. Every time, she described this person as being white, male, wearing all black, a few inches taller than her, she's 5'10", wearing a mask, skinny, athletic, toned build, and not a voice that she recognized. During 3 of those interviews, she then describes the male's eyebrows, and she describes them as being bushy. Obviously, there was some focus on the eyes or the eyebrows by investigators because this is the only portion that she could see. She never wavers in her description of the person that she saw. She's very clear about what she does remember and what she doesn't remember. Defense put the state of Mr. Koberger's eyebrows into question. In an attempt to discredit DM's testimony or description, they wrote, Mr. Koberger does not have bushy eyebrows. But the artwork on DM's walls and the way she draws eyes and eyebrows could be described as bushy, full, or prominent. So in response, the state attached a picture of Mr. Koberger. And obviously that's a jury question, but it was taken only hours after the homicide, so the closest in time to when DM would have seen the smell. And we did this in order to, when we did apply the Manson-Biggers test, to show that it turned out to be accurate. Corroboration does not equal prejudice.
Cooperation. Wait. I think I had a heart attack here when I heard that Ashley Jennings is saying that cooperation doesn't equal prejudice. What was being corroborated here? Wait, what?
The state doesn't intend to introduce, they're correct. We would not introduce that photograph through DM. We would attempt to introduce that photograph and plan on laying the proper foundation and relevancy at trial. There's no grounds to exclude this testimony. DM's the only living individual who saw the person responsible for these 4 homicides. Her description of the male, including any characteristics such as bushy eyebrows, is relevant to the identity of the killer. It is prejudicial, but it's not unfair. A jury should hear this evidence in the state.
Okay, how is it prejudicial? I disagree. Okay. How is it prejudicial?
Ask that the court rule accordingly. Thank you.
Okay, let's hear. He didn't have any questions for her.
I'll be brief, but I want to circle back to where I started. To say that there's no grounds to exclude this testimony is completely inaccurate because, in fact, there is a large body of case law and a large body of science about how important this testimony is. And that's why this court must analyze the reliability going through all of the factors that I expressed. And there is no
How do we even know that Dylan saw somebody?
certainty with DM in what she saw. And the court now has, over a variety of motions, all of the transcripts that you can look at to understand the amount of uncertainty that she expressed.
Thank you.
I just think this
I'll
is,
take that issue under advisement.
it's just not even going to be like a,
All right.
DM's just going to get destroyed off without anything that when she's going to speak on this at all, of like what she saw, what time it was, or anything like that. Like, I want to know, whatever. So Hitler right there is not going to rule from the bench there. He doesn't have, he's like, what the fuck? Okay. Right here. Text messages.
Must analyze the reliability to understand the amount.
4037. Oopsies. Here's Ashley. Okay, these are the text messages. Back up their 911 call. Here we go. It's
The
going to
state
be.
seeks a pretrial ruling that the audio recording of the 911 call and a transcript of that call are an exception to the rule against hearsay. The
Okay.
state submits that the entire 911 call should be admitted pursuant to IRE 8032 as an excited utterance.
There is no way that this 911 call is an excited utterance. The only person that I would contribute it possibly to would be to the kid that's hyperventilating, okay, and who would like come down to wherever they were. All right. If the person with the phone was walking around and seeing things as they were talking, that's an excited utterance. Okay. Like, it just is. I mean, it is. I couldn't tell if it was Hunter, if it was the other kid, to be honest. But sure, if it's Hunter.
At 11:49 a.m., BF calls her friend and to come over and check the residence.
Okay. Is that not weird? At 11:49 to come over and check the residence at 11:49. Why not at 10 or 9 or 7 or 8 or at 4:30 the night before?
The friend and a boyfriend show up to the residence. At 11:56 a.m., BF places a call to 911.
Okay, so just so you know who she calls Emily. And so her and Hunter Johnson come over. Allegedly, right? 11:56 a.m. So that would be 7 minutes. Now, mind you, remember they're like just next door neighbors.
Just 7 minutes later, this 911 call was immediately after learning that HJ had something was definitely wrong within the residence, and his instruction that the girl should call 911. The statements were before the declarants knew their friends had been murdered the night before. The requirements of IRE 803-2 are met, as this was obviously a startling event, and two, the statements were made under the stress and excitement that it caused, and that's clear by listening to that audio. The defendant has proposed that their version of the 911 transcript be used, and the state has no objection to that. And I do have a copy of that transcript and the defendant's transcript if the court would like it. Thank you.
I may ask you some more questions because it seemed to me from the briefs that the defense focused in on three particular parts of the 911 call as not falling within the exceptions. So you didn't address those specifically, but let me see where the defense is at.
Now, the best place for me to start is to probably provide you with some copies of the exhibits that we're going to want to talk about.
Ann Taylor wants to give the exhibits, which is the totality of this timeline. And she's going to start at 2 o'clock.
The first set I'm going to hand you was actually filed with the text messages. It's an affidavit of Josiah Roloff, and also, let me give you the extra copy. It has DM's messages broken out in bubble form. That's not all.
Okay. So Josiah Roloff's, basically everything that he found, Josiah Roloff is the expert, forensic expert, digital forensic expert. And then you have, so it's the bubble text. So it's from both sides. So what's interesting is, I don't know if you guys have iPhones. I have one. I could like go and click and delete bubbles off of and then if I took a screenshot after I deleted something and I took a screenshot of it, it would then just show the messages like they came in a certain order, but really weren't. So I'm curious if at any point in time, screenshots were first used to like, if a cop was like, here, take a couple screenshots of that or whatever, and, send that over as to the focus in on this whole bubble texting. Or if this is just how he
I do
does
have a
it.
separate copy for Giovanna. I think that's what I'm supposed to do.
Just to be clear, when we're talking about 911, but you're giving me text stuff.
We are, in our response to the state's motion about the 911 call, we referenced the whole copy of text messages. We just filed them with text messages, but they're appropriate here too for the court to consider. I have the additional exhibits that were attached to our response, and they are 1 and 1A. 2 copies. With those in possession of the court, I'll talk about the state's request. The 911 call is made 8 hours after whatever happened in that house happened, after the killings happened, according to the state's theory.
Right there. According to the state's theory. That is highly in dispute. Okay. 100%.
Of the case anyway. The state wants to play for the jury the 911 call and give them a transcript of the 911 call as an excited utterance or a present sense impression. The context of all of what happened that night is captured in DM's text messaging. There's a separate text messaging exhibit for BF. But it's not that all of a sudden at 4 a.m. something starts to happen and then the 8 hours pass and they call their friends and are startled by finding out that their roommates have been killed overnight. There's a lot more that happens during that time, and to analyze whether they're under the influence of a new and startling event, the court should take a look at all of the text messaging, all of the use of Snapchat, all of the use of Instagram that happened. It doesn't start in the middle of the night and then just stop until noon. There is a whole lot more that's going on in that house. When you hear the 911 call and you analyze each of those statements, the only statement that could possibly be a present sense impression is that from HJ. And he really doesn't say a whole lot. The other statements that the state wants to capture in, one is attributed to a person with the initials EA, and that person is repeating what she's been told. She says one of the roommates is passed out. And then a bit later, under prompt from either DM or BF, she says, oh yeah, and they saw a man in their house last night. Those are not things that relate to an exciting event. She's reporting things that other people are telling. She's not.
And I can't believe that no one's mentioning this. They say, Emily says the word they saw, you guys, not Dylan saw. Okay. They saw. Oh, and they saw a guy at 4 a.m. That's interesting. That's different than just one person.
Not somebody who observed any event in the house. If the court takes a look at Exhibit 1 that came with the 911 calls, it's a smaller transcript and it comes from the grand jury transcript. If the court will look at page 277, that's numbered in the top right corner, lines 16 through 24, EA did not see anybody in that house. She went in, went to the top of the stairs, and went back out, and she saw nothing. She never went back inside that house. Any statement attributed to her cannot be an excited utterance.
Okay, let's hear that one more time. I want to hear right there.
Thing starts to happen, and then the 8 hours pass, and they call their friends and are startled by finding out that their roommates have been killed overnight. There's a lot more that happens during that time, and to analyze whether they're under the influence of a new and startling event, the court should take a look at all of the text messaging, all of the use of Snapchat, all of the use of Instagram that happened. It doesn't start in the middle of the night and then just stop until noon. There is a whole lot more that's going on in that house. When you hear the 911 call and you analyze each of those statements, the only statement that could possibly be a present sense impression is that from HJ. And he really doesn't say a whole lot. The other statements that the state wants to capture in, one is attributed to a person with the initials EA, and that person is repeating what she's been told. She says one of the roommates is passed out. And then a bit later, under prompt from either DM or BF, she says, oh yeah, and they saw a man in their house last night. Those are not things that relate to an exciting event. She's reporting things that other people are telling. She's not somebody who observed any event in the house. If the court takes a look at Exhibit 1 that came with the 911 calls, it's a smaller transcript and it comes from the grand jury transcript. If the court will look at page 277, that's numbered in the top right corner, lines 16 through 24, EA did not see anybody in that house. She went in, went to the top of the stairs, and went back out, and she saw nothing. She never.
EA went in, went to the top of the stairs, okay, saw nothing, came back down, and went out of the house. So that would mean that when she was called at 11:49 and got over there, these people who never call the cops, right? That would mean that they called the cops before Emily would go. She's just going to take their words for it and be like, okay, I talked to them. Okay, let's call the cops. Well, no, Lana, because Hunter Johnson was supposedly yelling down to call the cops. Okay. If this is just me, though. If somebody's upstairs in my house and they're like, oh my God, call the cops, call the cops. I'm like, wait, what? Huh? Like, I'm going to go up to wherever they're saying call the cops. I'm not, for me to be downstairs and then just like, just think about how you would be. Like, oh my God, I'm just going to grab my phone, call the cops and say what? Say what if I don't know what's going on? What do I call the cops and say if someone's just screaming down to call the cops? You call the cops? What are you talking about? Call the cops. You know, call 911. What? And so then I call 911. It's just like, what? Now you tell me that those sorority girls you think are going to pick up the phone and call 911 and say what though? What do you want me to tell these people? What am I telling 911? What am I telling 911? I don't know what to say to 911. I don't know how to. I would be like, my boyfriend just told me to call 911. I have no idea why. Okay. So after I heard this, I went back and read the transcripts again of the 911 call. And I'm like, yeah, you know what? We even have a bigger problem. If, like, it's, I don't even know. I wouldn't know what to say to 911, right?
Or went back inside that house. Any statement attributed to her cannot be an excited utterance. She's repeating what other people have told her. So
She didn't see anything. That's why Emily's out.
similarly, If you look at the grand jury transcript, this is 1A, this relates to DM, and I'm at page 187, lines 12 through 16. DM is not responding to any of the statements she makes on the 911 call to a startling event. She says that for a brief second, she saw XK, but thought she was passed out from the night before.
She saw XK, but thought she was passed out from the night before. When did Dylan see XK? Do you understand that we're going to find out where Dylan's or where Xana's body was located and if the door was open or closed? And do you know that that means when did Dylan go upstairs, okay, and possibly see XK but not see Ethan? Just truly just think about this. I'm downstairs. I wake up in the morning at whatever time, and I'm like, okay, whoa, I had a think about it, a crazy ass dream or something like that. Like none of this is fucking accurate, right? But I had a wild ass dream. And I realized, like, whoa, why am I in fucking Bethany's room? Right? Okay, dude, I'm going upstairs. Like, you want to go into like your own room, right? So you would like get up out of bed, her bed, and then like go upstairs to your room, right? And then what, on your way to go into your room, I'm going to what? Maybe go over to Xana's room and now if these girls had iPhones and they had their data and it was on, we're going to be able to see. So how about this? If you go downstairs, it's not going to register a flight of stairs. Okay. But when you go up a flight of stairs, it's going to register. I'm curious to see how many flights of stairs they have on their phone. I'm just curious to know when she saw XK.
Also wants to talk about what she saw at 4 a.m, and the dispatcher stops her. Looking at page 190 of that same 1A transcript, DM talks a little bit about that morning when she woke up after whatever happened in the middle of the night happened inside that house, that she reviewed the text messages between her and BF from the night before. She was busy from about 9 o'clock in the morning on her phone. She was on Instagram.
She was reviewing. So at the grand jury, she said that morning I was reviewing me and BF's texts, like to see, why would you be reviewing those? Like is it because like you were sitting right next to, like laying next to BF and so you guys were looking at each other's, if I'm laying next to this person, right? And I wake up and I'm just like, oh my God, like what the hell? Why am I down here? And then BF is filling me in on, dude, last night you came down here, like you said you saw a mask and some dude in a mask or somebody was in a mask. Like, look at our texts. So just I'm trying to envision this. Okay.
Snapchat. She was on Indeed. She was editing pictures sometime in the night as well. This is not somebody who was asleep and then woke up and was startled. She is actively reviewing things that happened on her phone and communicating with other people. Any statements she made on the 911 call is not the result of a present sense impression. It's not the result of an excited utterance. It is somebody who's been awake and thinking about whatever she and BF talked about the night before and communicating with a lot of other people before that 911 call is made. The court should not admit the 911 call as an excited utterance, and the court should not admit the transcript for the same reason. But if the court chooses to admit one, having both is cumulative. So we'd ask the court to exclude the 911 call.
Judge, I think there's a misapplication of the rule as well as the event that is causing the startling event.
Okay, so hear me out. If I'm Ann Taylor and I'm going to show that these girls aren't being truthful and that they were deleting a bunch of stuff, and I kind of, why wouldn't I want the jury to hear the 911 call if I'm going to show how it was kind of like staged in a way. So, how do I want to say this? I'll come back to it because because in a way it'd be like speculating in a way, but okay. If I woke up at 9 or 10 o'clock, why am I waiting till 11:56 to have somebody come over to check the house? If I woke up at 9 or 10. For Bethany's sake, I mean, she was up at 7:30 texting her parents. So why would I, or was it that I was trying to get in touch with people, but nobody was answering me because they weren't waking up, my other friends? Like, but why would I wait till 11:56 to call somebody over to have them go through the house? Why wouldn't that happen at 9 or 10 in the morning? If I truly fell asleep at 4:30, 4:37, and then woke up and I'm still afraid, there's no way. Because it's light outside at that point. Like, no one's scared in the mornings. They're scared at night, okay? Just so I'm just like think about that. And if you were so kind of like fucked up, you would kind of like, you wouldn't, if you thought it was just people playing pranks on you or whatever, like you would never still have that fear in you. Like that deathly, like to call. I could never imagine sleeping in my bed, seeing a masked man in my house, sleeping in my bed, and then calling somebody to come over my house, the house that I'm in, for somebody to come check my house that I'm inside of and have been in for the whole night. That is just not normal. You wouldn't do that like that, okay? You would call somebody over because you don't want to be the person to deal with what you know that they're going to find. And so you want somebody else to find it? And that would mean that you had prior knowledge of what they were going to find. For the life of me, and it's going to come out of trial, I find it hard to believe that Bethany Funk on Sunday mornings would call her parents and blow them up between 7:30 in the morning and 8:15 a.m. on Sunday morning. You're going to be able to show a pattern of life and what these people do. And I am willing to put a ton of chips on the fact that Bethany is not calling her parents between 7:30 a.m. and 8:15 a.m. on Sunday mornings. So why would Bethany be calling her parents she better have some really sweet ass reason for that, because I highly doubt, and of all the years I went to college, I was not ever calling my parents at 7:30 in the morning on Sunday mornings. Never once did in my life, I don't think. And so what you're going to be able to show is that they did it in the Monica Simontelli case. It's going to be used in this case. That the actions that happened on that night or early morning hours and when they woke up, none of which they normally do. And I think Ann Taylor makes a really, really good argument. And so does like the rest of the team when they say Dylan had to go downstairs and would have passed the door to like leave. Okay. Bethany's right by the door to like leave. Dude, there is no way that chicks who are sorority chicks, okay, are not getting the fuck up out of there. Or everybody's still up kind of still at that time. Why aren't they calling people over there at 7 or at 4:30 in the morning? Why aren't they calling Hunter Johnson and, to come over at 4 o'clock, 4:30? You guys, if I saw a masked man in my fucking house, I don't care if I was blazed, drunk, that'll sober you the fuck up, don't you think?
Or the reason that they're startled. State agrees that this is somewhat of a culmination. There was definitely a startling event around 4 in the morning when DM opened her door and sees an unknown person in black in the house. She's not sure what to make of this, but that's obviously a startling event, enough so that she runs downstairs to her friend's bedroom. Yes.
Why didn't she run upstairs to her friend? Why didn't she run on the same level to that person's bedroom? Well, because none of those people were answering. Right?
Period of time elapses. She wakes up the next morning.
Just so we're clear, a period of time elapses before she goes downstairs.
The next startling event is the fact that when she wakes up the next morning, her friends, she can't hear them. And she's texting them, and that's what her phone records show. She's texting them, giving them time to respond, and they're not responding.
She doesn't text them until 10:30 in the morning. She doesn't text Kaylee and Maddie until 10:23 in the morning. 10:23, 10:30.
So at this point, she decides to call over friends to come and check on the residents. Remembering what happened?
Okay, now how kind of crazy is that? So why would you bring in friends for them to go get fucking hurt? If you don't know, because she just says it right here. Remembering what happened the night before, she's like, okay, I'm going to bring in friends. Do you guys understand that I would never think in 1,000,000 years that my roommates were killed or murdered? That wouldn't even enter in my mind. But I'll tell you what would enter in my mind is to go and help them. Remember when Dylan said that she thought she heard Kaylee, coming running down the stairs, and then she went and saying that there's somebody here, and then she goes running back up the stairs? Okay? I want to know if it's at all possible that Kaylee actually said there's somebody here because of like what was going on that she heard in Maddie's room or whatever, and was able to maybe like get away for a second, run downstairs, but that like running back upstairs, or could she have possibly gotten like pulled and dragged to come back upstairs? Or did she go back upstairs to help Maddie, and other people like they ran away? Because I'm just trying to envision, Dylan specifically saying that it was Kaylee's voice. She didn't say Xana, she said Kaylee, and the state wants no part of that. And I keep on asking myself, why? Because even Hitler, good old hippie over here, is like, it still could have been her. And then she just gets killed after that. But the state wants no part of that.
Happened the night before. Now adding to that she's not hearing the roommates above like she normally would. And they're not.
Wait, if she normally would hear the roommates above, is she on the second floor then? If she's all the way at the bottom, like, so that, like, this is, it just brings into so many things. Like when she wakes up in the morning, does she get out of Bethany's bed and immediately go upstairs? Because I'm going to tell you that why would I want to continue to lay in somebody else's bed when I want to like get in my own bed and be like, you know, my own, like, I don't know. I just want to go get in my own fucking bed, go in my own room and do my own things. Like, I don't. So, but I'll tell you this, if she can't normally hear them like she normally does, well, she normally is sleeping in her bed, right? So she has no idea what the fuck she normally would hear down on the first level. So that tells me that that's a crock of shit if she was still on the first level, because she's normally not down there. And so you wouldn't be able to hear like you would normally hear if you were on the second level.
Not responding in the morning like they normally would. Then she calls her friend to come over. Then the friend comes over, discovers Santa, and then instructs them something is wrong. And to the point that they need to call 911. That's truly the startling event here, is the confirmation that all of these things are coming together and that there's an emergency in the house.
That's true. Listen to her. And that's truly the startling event here. So Ashley Jennings is now saying that during the middle of the night, there's nothing startling. This is the true startling event is this, you know, at 11:56.
That law enforcement needs to respond to, which is the context of how all of these statements are made.
What's your response to it seems like some of this I need to take bit by bit. And so, for example, EA stating that one of our roommates or one of the roommates passed out and was drunk last night. She's not waking up. She didn't witness anything.
Well, I think that falls under her presence and suppression of what is happening at that time.
Her hearsay statement of what somebody else told her.
That's
she's
true.
not experiencing anything in that sense other than being there. And I think the case of my note here.
Why is nobody bringing up what Ann Taylor just supplied them with? How come Ashley Jennings is not being asked these questions, which is, okay, well, Miss Jennings, what Ann supplied us with right here, it would indicate, you know, when you guys were, these deletions, why are all these deletions gone? Why is all this activity? I thought you said that they were sleeping. Go look at what Ashley Jennings tries to put in and say, here, this is where we want stuff to start at, which is the state. Remember, wants you guys to believe that the girls were sleeping until they woke up in the morning and realized that nobody had, you know, wrote them back. So then they had messaged the girls, you know, with those text messages at 10:20, 10:30. Like, doesn't this change the whole timeline with everything? No, there's no answers for that. Remember, let's go back to the whole make and model. Let's go back to where he's like, those aren't the facts. Remember, that's not how I see the facts. So are we going to have a case of like the Karen Reed case where we're going to have experts arguing and saying that, oh, that never happened? I don't know where you're seeing those deletions. It's not like that. That's not what I have. I don't know where you found that. That's not really a deletion.
Bemis is instructive.
I mean, they want phone conversations between the two girls to come in from around the 4:18, 4:19 in the morning.
Well, I would also argue that for this particular statement, we wouldn't be relying on it for that truth. So therefore, it's just not hearsay. Well, solely just for the context of the entire 911 call. But we wouldn't be asserting that what she was saying is true, that the roommate is passed out and she's not waking up. That's not the purpose, or that my friend's telling me that she saw someone in the house last night.
What's the
It's
purpose?
not offered for the truth. You better have a good answer about what the reason is other than the truth. I'm not hearing one.
Yeah, what's the purpose?
Only that it's part of the substance of the entire 911 call. And that part could be redacted, which still, that doesn't mean that the entire call should be redacted.
If I'm addressing them individually. I mean, there may be parts that qualify and there may be parts that don't.
I still argue that the entire call in its entirety.
Well, so here's kind of the way that shakes out. If you offer the tape, you as an initial matter can't put in stuff that is hearsay. It's unaccepted hearsay. They want to put in the context if it falls under the completion doctrine, they can't. If it's the other way around, in the defense first plays the tape, and parts are hearsay are left out, and you want to complete it, you can. But you don't get to complete with hearsay your own offered conversation, or I think it applies outside the federal context to recordings and testimony.
Yes, that makes sense to me.
Okay, so then I had the epiphany. Okay, and they need this. The state needs this because they're going to show that these girls had no clue what had happened. Okay, and that they delete stuff all the time, and that has nothing to do with, like, that stuff wasn't relevant to what happened. They were oblivious to what happened. You can clearly hear it. If we play this 911 call, you're going to hear how these girls just found out about all of this stuff. And guess who gave me that epiphany? Right there, Hitler did. So think about how nasty that is, that you're trying to basically get in front of what you knowing about the dialect between Dylan, Bethany, and what their phones will show. And we're just going to say, well, none of that matters because they're deleting, or they're doing this, or they're doing that. Like, it's like, wait, what? None of that matters. What the fuck are you talking about? These are two people that were not, these were two people that were not even attempted to be harmed. Like, it wasn't like they escaped and they like somebody was coming after them, and that they were able to get out of there, get in a car, and get the fuck up out of there, and drove to the police department. And they just, because that person was going to try to kill them. Okay. These people were unharmed to the point that they weren't even attempted to, like, nobody was going after them. In a house where everybody's basically on top of each other, literally, figuratively. Look at the house. It's all on top of each other. That house is way closer than in tighter spots than you could ever imagine. And here, a girl that's opening and closing her door 3 times and potentially yelling stuff out according to News Nation. And then is it within 3 feet of the actual killer, and she's not like what I could more or less see is that somebody running away and them getting away or something. But it's really truly interesting. And nobody addresses the fact that Josiah Roloff comes flying through here with like, we have some hella shit going on with these phones. Do you guys not like, can you imagine if we find out that during these police interviews that none of these police officers ask these girls, hey, so what time did you actually end up falling asleep? Why are you like you're doing all this texting? Then do you normally call your parents at this time? I mean, do we think that any of that stuff happened? If you don't have the name and you have no leads, aren't you going like, hey, we need to talk to you again? Like, thank you. You gave us your phones. We downloaded them. I cannot wait to find out the date that those phones were downloaded. What's the date? Because remember, let's say that it was a couple days after the murders versus on the 13th. You're actually going to get way more out of it because you're going to get people talking about stuff after the fact. But if those phones were downloaded, let's say on the 13th, then any communication that any of these people would have had after the 13th is not they don't have that. Like, remember, like in Jen McCabe's situation, they didn't download her phone until February, I don't know. So they had the 29th, the 30th, the 1st, I think the 2nd they downloaded it.
So when you say for the whole context, that sounds like the completion doctrine, which I'm not sure you get to rely upon. Well, know you don't get to rely upon. And so when you say it's not offered for the truth, I'm not hearing something other than the completion doctrine that you're telling me about.
I think that's fair. I mean, we only have certain exceptions to the rule. If it, I still believe that the entire call in its entirety and under the circumstances that the call was made, the entire call could be considered an excited utterances by all declarants.
No, Ashley.
Also, there's a statement by EA, oh, and they saw some man in their house last night. Yeah. That seems to me to even be more removed. Again, it's a statement of a hearsay of somebody
Boom.
else. So we got hearsay within hearsay. And not by somebody who observed that and relating to the event that happened previously.
And so when was that given? And if these girls thought this was just all a big prank or something like that, what's being offered up by Steve, that even makes it worse. If people thought this was a prank, then there's nothing to be scared of in the morning. You're not calling people over. And then, Steve comes through and says that Hunter thought that they were playing a game with him. Like, remember the whole rolling term? Just
That's true.
So what non-truth purposes is that statement?
Again, I would just have to say that the whole
Because
call is
that seems
excited.
to me to be even more concerning.
Right.
The first one, I mean, my roommates aren't waking up, and we're going to have that confirmed through other evidence. The statement hearsay that the roommate saw somebody is perhaps more of a piece of contested evidence.
Agreed. I still,
Concern about being an offer for the truth is even greater there.
right. And the appropriate remedy, when there's not any grounds for relevancy for this, would be to solely redact those portions of the 911 call, not to exclude the entire call.
well, what part of the 911 call isn't? That's the issue. Not happening.
And based off of the nature of the call and the fact that the phone is passed around multiple times, and it's hard to determine who's speaking at what times. And obviously a lot of emotion in their voice considering what's going on. It's not always clear to understand what's being said. So I think a transcript is a fair way also to convey this and should be allowed with the audio. Nothing further for the state.
Transcript of the testimony. In other words, you're essentially admitting the evidence of somebody who transcribed it to say this is what they said. So to me, there's two different questions. One, should the 911 call come in? And second, should I allow, if there is a disagreement, a transcript?
Well, the state has offered to allow the defendant's transcript that they had certified.
The fact that certified doesn't make it otherwise admissible. It's hearsay. The transcript part of it.
Well, it's a transcript of the 911 call. I believe that it could be self-authenticating.
It is flat out hearsay. It doesn't beat the
It has
rule.
sufficient standards of reliability built into the transcript.
That may be one. 24 might be a hook. You haven't complied with the requirements of 24 at this point.
But we haven't met our exhibitor witness deadline yet. So obviously we would have to lay the proper foundation for that and would intend to do so.
And I think that what I always try to look at is, why does a side want something? When you ask yourself that question, like, why does a side want something? Like, what do you want out of this? Why is your reasoning for doing it? What's the reasons? And I just think that they're to bolster the testimony that's coming from DM and BF. I mean, DM and BF are testifying for the state. There is no doubt about it. There is no way around it. Okay. Anybody that's out there that's saying that those two are not testifying, those two are testifying for the state. They are the timeline for the state to be able to say that these murders happen when they're saying that they happened. And that is just that's going to be interesting to see the testimony and then the cross-examination of it later.
I think I need to take a statement by statement approach to this. Do you think that the surviving roommates, surviving victims of the burglary,
And he says surviving roommates of the burglary, you guys, because they like that's one of the crimes. They're not a surviving of the murders because there was no attempted murder. Okay.
were under the stress of the immediate events. But there are some questions about some of the other statements in there as to whether they will come in. So I think in general, much of the 911 tape meets the qualifications, but not all of it. I think there are concerns with some of them as I've outlined in my questions, but I will write that because to give you more particular guidance. All right, the text messages and testimony.
Okay. Text messages now. That was just the 911 call. Here we go. This is the text messages.
Thank you, Your Honor. Similar motion by the state asking to bring in the phone records for DM between 2:10 a.m. and 4:37 a.m. on November 13th, as well as related testimony around that same time between DM and BF. Again, the state submits that there are allowable exceptions to the rule against hearsay to allow these statements to come in. I broke those down in my motion and reply and the applicable rules for their introduction. This is a much easier piece of evidence in order to be able to present certain time periods and not put in non-hearsay. It's much easier than an audio recording where we would have to redact. But for the messages that DM sends and the messages that BF responds, I think all of those are allowable under the excited utterance, as well as the present sense impression exceptions to the rule against hearsay. If you have any questions about any specific messages.
Hands and argue it.
Well, Your Honor has our exhibits already related to this, and then in the record were BF's phone activity. I don't need to quote extensively from those. There's a lot more to the text messages than the state has provided to the court, and the lot more makes a difference when you put all of these into context. We went through some of those in our briefing, and the court can see that there's even more when the court looks at the exhibit. I understand from the court's previous statement that the court would accept a complete copy of something versus just pieces of it. Well, I could offer
For
it.
the completion document, if it's necessary to explain the prior admitted stuff, and it's close enough actually in time and subject matter, and so there's some questions there. It's not just automatic.
We certainly
What?
would understand that we'd have to present some information or cross-examine witnesses about that. The additional bits of information that are contained in that record around that same time frame, though, provide a much better context when we're talking about other communications with social media, with saving pictures, creating new contacts in one's cell phone right before the texting starts between DM and BF, and then subsequent to that, looking at
Okay, right there. Very important timeline. And this is where I'm going to end it on today. This is right before the texting starts. Okay. Wait.
the additional bits of information that are contained in that record around that same time frame, though, provide a much better context when we're talking about other communications with social media, with saving pictures, creating new contacts in one's cell phone right before the texting starts between DM and BF, and then subsequent to that, looking at pictures, editing pictures, calling family members. There's a much bigger picture than just this tiny little piece of texting between the two parties there at night. Further context about these messages the court should be aware that it's not just these messages. There's a lot more activity going on between these two people, and it's hard to tell what it is because there's telephone calls and those kinds of activities, as well as going down to one another's room, spending the time together, talking to each other, really take it out of an excited utterance because it's an entire transaction between the two people. It's not just a tiny little piece of context with this group of text messaging, and the whole is what matters here and takes it away from being excited utterances because of the other activities of the two people.
The activities that occur after. So, for example, the texts between at 4:18 or 4:20 or whatever, those aren't affected by the later activities of surfing Instagram or whatever. And I'll be interested to hear the testimony of the two young ladies because my experience with that age group has shown that where you or I might phone somebody, others might check out their social media to see where they're at or what they're doing, right? And so understanding how they
What the fuck is he? Okay. I mean, I can't believe this. Okay. Ready for this? What are you talking about, Hitler? Okay. Checking out social media to see the whereabouts of somebody. Where is he getting this argument from? Are you suggesting, Hitler, that they were on Snapchat to see where their friends were located at? Like, what friends? Were they looking on Snapchat to see the locations of their deceased roommates? Well, they got their phones and they're still in their rooms, or their phone up. If your phone's dead and you're not going to be on, like, if you're sharing your Snapchat locations, it like literally can pinpoint you down to where you're at on Snapchat if you're sharing locations. Okay. So I thought about that and I'm like, what is he talking about? Going on Instagram and seeing, you guys, explain to me how you can go on Instagram and see the whereabouts of somebody. Please enlighten me. How can you go on Facebook and see the whereabouts of somebody? How can you go? The only thing I know of is going on Snapchat. And if you are sharing locations with people, that then you would know exactly where they were. You could zoom in on a little map and it has your little avatar and you're just shaking it with Detective Mowry at the corner club, or people could use that actually to a way to find their phone as well. But tell me what the fuck is he talking about to find the whereabouts of somebody? Who, what, when, what time frame is he talking about? I mean, Indeed is a that's the. So have you guys, if you could please enlighten me in the chat here, how you can go on Instagram and be able to tell the whereabouts of your friends. If you make a post on social media, you can tag any place, you guys. I could say I'm in fucking Boise right now and put a post up and tag myself at a fucking bar in Boise. Doesn't mean I'm there. And nobody goes on social media and does that. What is he talking about? That's not what these people do. If you're going to do anything, you go on Snapchat and that's how you would see locations. But now you think all these kids just stalk each other? This is absurd.
are using those apps, check out their social media to see where they're at or what they're doing, right? And so understanding how they're using those apps is also important.
Yeah. And do you know how they're using those apps, Hitler?
It is important, and I would refer the courts to our affidavit from Mr. Roloff. I'm talking about the Snapchat activity, talking about Instagram, and there's a way to tell if somebody's active on Instagram versus just having it open in the background of their phone, and those are things that were going on, as well as editing pictures. The picture editing happened in those overnight hours. Instagram happened later in that morning.
Wouldn't affect the excited utterance and present sensation of the earlier report.
Talk about yes, it does. And I quickly put right there, I'm like, right there, you're going to argue the time of the crime, and you're going to argue that, let's see what Ann says. The crime, time of the crime, Ann. Time of the crime.
They retreated to the room together, and and what happened there.
Mostly, I agree. There were things that happened right before. DM created a new contact at 3:51 in the morning.
Right there. There was things that happened right before DM created that new contact. So not only do we have the 3:51 new contact at 3:51 a.m., but something happened right before that. Something happened right before her creating this new contact, which, remember how I was telling you guys, well, I've done it before where I've handed my phone to somebody and they'll create their own contact in it, because I'm just like, well, here, you put your own fucking shit in there. Like, I'm not, because the last thing you want to do is get the information wrong and then you're calling, the wrong person or whatever. So what did she do right before the saving of that contact? Making a new contact, something happened right before that. Usually you're in the presence of somebody when you're saving a contact, or somebody just sent you something. Okay. They shared a contact, and then you're saving it as a new contact because you could have been texting with the person and there are just numbers in there. And then you finally like save them as a contact. But it would show based on text messages that you were in fact texting with them a lot longer before then you save them as a contact. But who the fuck saves somebody a new contact at 3:51 in the morning?
Before anything happened that was of an excited nature.
If you accept the state's timeline for that, and we don't know that yet.
Boom. There it is. If you accept the state's timeline. If you accept the state's timeline. And that to me was the biggest bomb of the motion in Limine. If you accept the state's timeline. That's where I was just like, that's where I lost it. And I was like, exactly, boom, bombshell. If you accept the state's timeline. And if you did not thoroughly vet Dylan and Bethany, then it is going to explode. Because this is what makes it explode. When the police would have found out that there was these deletions and that other things were going on that they were doing with their phones, and they didn't investigate that to find out what the fuck is going on, how dumb can you be as an officer? The fundamentals of crime begins with a timeline. Like you learn that 101 in criminal justice. Boom.
Foundation that will have to be laid, but that's their version of the time events, and that's then the jury's job to figure that out.
Sign me up. Wait, did you just hear this? Like,
Shortly,
Version of the time events, and that's the
don't know that yet.
Boom.
foundation that will have to be laid, but that's their version of the time events.
whose version? Whose version? The state's version of the time. Wait, what are you talking about? Evidence that doesn't exist or evidence that has been manipulated. What do you mean that's their version? So Hitler has no problem that their version is surrounded by deletions and lies in interviews about what time you woke up and what you were doing. I mean, this is absurd. It's fucking mind-blowing.
Mostly, I agree. There were things that happened right before DM created a new contact at 3:51 in the morning.
Before
There-
anything happened that was of an excited nature.
Before anything that happened that was an excited nature. That's what he just said. He thinks it doesn't fucking matter what was going on then. And then here's the answer saying,
If you accept the state's timeline for that, and we don't know that yet.
The
Boom.
foundation that will have to be laid, but that's their version.
it'll be foundation that has to be laid. Who? Who has to lay this foundation that will have to be laid? What the fuck are you talking about? The state, the burden is on the state to lay this foundation, to lay this timeline. Right?
Version of the time events, and that's then the jury's job to figure that out.
Sign me up.
Shortly after the last text message, and I'm talking just minutes, DM and BF are doing different things on their phone that night as they get together that night. There's the
She says, as they get together that night.
period of time that they're together in that room, both before there's a break in activity. There's not really a break in DM's phone. That is pretty well continuous. And there is a break.
Right. There is not a break in DM's phone. DM basically did not go to sleep. Do y'all hear that right there? Who wants to fight me on that? There is not a break in DM's phone. DM did not go to sleep. Okay. Massachusetts has been having national standouts for I couldn't tell you how long due to Jen McCabe doing this type of shit. And the entire world is in an uproar over the fact that Karen Reed supposedly, allegedly was framed. And they planted and placed all this taillight, just sprinkled it all over the fucking lawn of 34 Fairview, right? And they're the police were involved in this. Okay. Karen Reed has all these fucking supporters that say that the police, as well as third-party culpability people, that were civilians that are close to police officers, were involved in this huge ass frame job cover-up. Okay. And Karen Reed has people literally cheering and chanting. And then come to find out, one or possibly two things happen on Jen McCabe's phone of House Long to Die and the cold Google search being, had happened and then deleted and then double put in to like kind of cover up the deletion, whatever. I mean, and then here in this case, we can't get a peep, not a peep, out of mainstream media, out of actually nobody to talk about the fact that, wait a second, these girls who said that they passed out and went to sleep, these girls who said that they just woke up at 4 o'clock in the morning to this incident, to a masked man in the house, but really they weren't because of the activity on the phone, and then saying that they were sleeping, and the state is backing that fucking shit. That is no different than the Commonwealth backing Jennifer McCabe. And I have no, this has nothing to do with Brian Cover being guilty or innocent. This has to do with investigators investigating something. When people tell you something, okay, great, then you have to go and vet it. And they would have known immediately when they would have vetted this, that this is not true. And then so there, this timeline of when this supposedly happened would have been immediately like in jeopardy of like, okay, is this, how can we even say that this happened at this time? Well, we're going to go off of those girls who we just found out they were lying to us, or they don't even, they're drinking. Then what? It's all unreliable.
For BF, but it starts again right away. So I understand the court's looking at an isolated part of time, but I think it's important to understand what activity was happening leading up to that and what activity happened immediately after that, when the two of them are together downstairs, to put it into context. One of the other concerns is the use of this text messaging, not just through the witness that's testifying, but to bolster each other's testimony or to bring in somebody else's statements through another person. So I think that it's important when the court analyzes if this is really an excited utterance to look at what's being said, as well as to understand the context right before and the context right after, not the next morning, the one's continuous, but right after.
Well, there are several things I have to look at. One is, first of all, is it hearsay? Is it an assertion, right? So is it offered for the truth of the matter asserted? We get to those two.
That's exactly what it's going to be offered for. They want to admit and be able to talk about DM and BF's phone conversation for 31 or 41 seconds.
Two things. Then we look at, is there an exception? For each of those two things, it generally means an out-of-court statement. Then it's, unless otherwise definitionally excluded, hearsay. Unless there's an exception, then the exception being the excited utterance. And then we look at the surrounding events. Is it common or current present sense impression? Look at the surrounding events, what's said. Much of it is not assertions necessarily, or I would imagine some of it not offered for the truth, but simply to establish a timeline. And so I'll look at all of those things, but I don't think I can just look at the whole thing in whole and say, well, because they later on were doing things that 19, 20-year-olds do with their phone, doesn't mean that what happened earlier wasn't an excited utterance.
I understand. Our position is that those things that happen immediately thereafter impact the nature of those text messages that occurred between the two.
All right. Next item.
And that's where we're going to end tonight. So I feel really bad for Dylan and Bethany because this does not change what's coming. And I believe in my gut that the police were like, we don't give a fuck about any of this drinking or the drugs or anything like that. Remember when Steve Gonsalves came out and said, they don't care about this. They don't care about the drinking or the drugs. Anybody, everyone just come forward and you know, give up whatever, da da da. Remember all that stuff? Well, I think as much as that could have been for anybody else, it was just as much for these two girls. So I just can't imagine that these girls are going to testify and say that nobody ever asked you about your phone. Nobody ever asked you that you deleted all this stuff. Did you guys delete things? Ann Taylor has to get all of this out in the trial through experts. She's not going to be able to hand them their like Cellbrite dump reports and say, "Do you see this here? Do you see how it shows that, you know, it's gonna be, oh, gosh." Like, for example, is there a way that Dylan could have, that stuff could have happened earlier, right? And then Dylan passes out, and then she wakes up, she saves a contact, and then she texts Bethany about it. Even though it had happened earlier, but she kind of like just blacked out and didn't realize that she blacked out, and then she just like fucking was texting about it. I mean, and then she left her room, and that's when she saw, you know, Xana, and then so she starts writing all this stuff that she truly though witnessed, like let's say at 3:15 in the morning. It's pretty wild. AT has to be so gentle with DM and BF because the jury will see two fragile girls. It depends on how you go about it. I think in opening statements. I mean, I watched the Karen Reed case the first time around, and Jennifer McCabe was literally grilled by a male, Alan Jackson, on that stand. Literally grilled. I don't know. I don't think that you need I fault the state, man. I fault the state. I fault the police. Yeah, Alan Jackson tore the fucking shit out of Jennifer McCabe. It just doesn't make any sense. You know what I mean? Like the story doesn't make any sense. So when the jurors hear the story and say, wait, 911 wasn't called, but you're so scared. And then you wake up in the morning, you're using your phone, you're doing all this stuff. Like, do you go the route that just none of this is reliable? And that so the crimes didn't even happen at that time? And the state is solely relying on the timeline of Dylan and Bethany to then place all of this emphasis in on this vehicle that they just think is, you know, the killer's car, and it had to be at this time. And so I don't know. But thank you guys so much. I appreciate you. Dylan saw the white wall behind her mirror with a drawing on the wall in the dark, so she identified herself 3 feet away. There you go. That's interesting, right? Blue-Eyed Candy said, $20, thank you so much. Does the text and the phone record show Dylan ever calling her boyfriend during the 8 hours? Wouldn't she call her boyfriend if she was freaked out, even if he was supposedly out of town? I just know that if this was a prank, I think that you would see text messages that were saying things of that nature, like, you guys knock it off. Like, okay, you guys got me. Okay, like, I'm freaking out. Like, you guys fucking got me. What if it's all really an hour behind, like how Xana began on TikTok, went from the being at 412 to 316. Everything really happened between 3 and 4. Yeah, I want to know more about the DoorDash order. Now, the DoorDash order and what time it was placed and who really made the order matters, in my opinion. If it was made, what device it was made from. So, because that's a user, somebody that was using their phone. And yes, could it actually be done by somebody else with that phone to like stage it? Sure could. Okay. Absolutely. But that would be a lot of premeditating and planning. So, Lana. I can't possibly believe that Dylan doesn't go to sleep and is just hanging out chilling in her roommate's bed downstairs. And you know how annoyed I would be if I'm trying to sleep in my bed and this person's just on their phone the whole fucking time and I'm trying to go to sleep. I don't know. Wild. Super sad though. I believe the DoorDash was for 2 orders. I don't know if you guys know this, but you can go on DoorDash, and if you get into your app and you can just like hit a button that will do like your last order, and you can just like reorder like what you got the last time. But it's wild to me that nobody's like even addressing the fact that all these phones have been manipulated and deleted. And you have an expert that's saying, yeah, we got some problems here. But then you have the state that says either A, we didn't know about any of this shit, right? Remember, because none of these people from the state that are experts have turned in reports. And that's when Ann Taylor's big thing is like, well, they're not testifying to anything that we don't have disclosed to us. So who are their friends? Who are their forensic digital examiners? Like, what are these people testifying to? These people should have a report out and to show like how just Cy Ray just went and testified for the prosecution a couple weeks ago. And he laid out Monica's life movements and laid out Baker's movements and laid out all these people in connection with the killing, laid out their movements on what they normally do over the course of months, leading up until the day and the night of the murder. I mean, that's what these people do. That's what location experts and then the forensic digital exam, they can go through your phone. And so it's like they're not looking at any of that stuff, right? And the state is going to solely ride on that sheath, the DNA on that sheath, and the fact that he's got this white car, looks like that car, and that he shut his phone off during the time of the crimes that we are alleging that happened at this time. We're not going to talk about any blood. We're not even going to try to find out who this blood belongs to, because we're going to say that blood was there from before the murders. These girls just deleted the stuff out of their phones because they were scared. It involved activities that aren't legal. I don't know. But again, thank you guys so much. On your way out, thumbs it up, thumbs it down, make yourself known. See you on the flip side. Thank you, moderators. Much love. Peace out.